Okay, so we have some questions about what is the difference between a lawsuit, an appeal, or litigation? And I get that question a lot. So I'm going to answer it from the perspective of an immigration attorney. And my name is Helen Tarokic. I'm a North Carolina board certified immigration law specialist. I'm here with Maya today. We just wanted to kind of go over in the T visa context or in the U visa context, what we typically have seen in the past and how things are currently handled. Because of course there are some concerns about what would happen if a U visa case was denied or what would happen if a T visa case is denied. Like what does our law firm typically do? And of course, this is not case-specific advice. This is really just general information so that people can have an idea of what these terms mean and what we normally try to do in the event of a denial of a T or U visa case. So if a T or U visa case is denied for somebody who's physically inside the United States, then we will normally get a letter from immigration that is sent to our office. As many of you may know, U and T visa applications are confidentially processed by the Immigration Service currently. It's January 2025 at the time of this film. And so if they have questions, they're not calling us, they're sending us a letter. And then that's usually known as a request for evidence. Then if they decide not to approve the case, again, they're not calling us. Immigration is sending us a letter to our office. And usually that letter explains the reasons for the denial of the T or U visa application. If we receive that letter, it almost always will say something like, you have 30 days to file an I-290B. We call that an I-290B. And they'll maybe say you have 33 days if this letter was received by mail. And again, we receive these letters by mail, so it's usually a 33-day rule. I don't like to play around with the 33 days though. Snow and other natural events and mail processing issues can come up. So we do try to file within the 30 days if we have to file an I-290B. An I-290B option offered by USCIS in the event of a T or U visa denial. Well, there's three different boxes that we can basically check. One is appeal, which basically means we think the government made a mistake in their legal analysis that harmed the case. A different box we could check on the same application form. It feels like an appeal, but it's called a motion to reconsider. And it means we would like the government to reconsider the information in the case that we've given and make a different decision, right? We think they got it wrong and they should approve the case. And another box that we could check is a motion to reopen, which usually relates to something like, it's not about the old evidence necessarily. It's more about, is there some other new evidence that the government didn't have at the time the case was denied that we now have available to us? And so we want them to reopen the case and consider that old evidence. Whether we choose the appeal, motion to reopen, or motion to reconsider box has some legal implications, meaning the standard of review that the Administrative Office of Appeals has might be a little bit different for appeal, motion to reopen, or motion to reconsider. Those are things I usually handle with our attorneys and legal assistants internally to decide which of those boxes we're going to check, because again, it's the same form. And it's really about at the end of that 30-day time when we're submitting our response to immigration, which is the best box checking option we think will be the most favorable to our client's case. But for some of the boxes that we check when we file the I-290B with immigration, asking them to change their decision, sometimes we have an additional 29 days to send in additional information or evidence, which could be really important to a case, and other times we don't. And I've also seen situations where some people have said, well, if you check one box, you're only going to use old information and you can't use any new evidence. Like, say we got a new T or U visa certification or a new good moral character support letter or something really interesting happened that would be favorable to the case, and we'd want to include that. many times, if we do have new and good information, regardless of which box we're going to check, we're going to go ahead and include that new information anyway, because I've never had a situation where they were like, we refuse to consider that new information. They've generally taken it into account if they received it, regardless of which box we checked. That may not always be the case, but it doesn't hurt to include new and favorable evidence if we think it's appropriate. So the Administrative Office of Appeals receives a motion to reopen, reconsider, or an appeal, and usually within 6 to 18 months will make a decision. But that office is within the Department of Homeland Security, USCIS. Well, sometimes that may feel like sort of the same people who made the first mistake, folks a little bit higher up or on peer with them are essentially going to be charged with making the new decision. Um, so I don't always love that, but there are reasons for us to do this in certain cases, and I've got two main reasons why we may choose to file an I-290B. The first reason is under the Biden administration, if a T or U visa case or other types of cases were denied, a person wasn't sent a letter saying they would have to go to basically immigration court. A notice to appear for deportation proceedings hasn't been sent generally if a T or U visa or a similar case was denied under Biden. But under the previous Trump administration, they created this rule. They called it the NTA rule, which was if a T or U visa was denied, then they would issue a notice to appear for removal proceedings to the law office for the client, where a person would then have to defend their deportation. But this is very important, so hear me out. That rule only triggered a notice to appear for removal proceedings if the person failed to appeal or file a motion to reopen or reconsider. So the I-290B filings that we did under the limited amount of denials that we had under the Trump administration were designed to, of course, win the case, but also it was designed to avoid a notification to have to go to immigration court generally. Now, sometimes people may want to go to immigration court. They might have an alternative option to legalize their status through an immigration court, and those hearings can take several years to be scheduled. But for the majority of people, avoiding a stressful court experience is the best thing for them. Again, just general information, not specific case advice here. So we would often file the I-290B because it would avoid a notice to appear under the Trump administration. And I expect that under the Trump administration, we may see a similar rule or different rules come into play. So if someone's case is denied, we're certainly going to be looking at the I-290B option. I don't really refer to I-290Bs as litigation because I'm not, I mean, it is in some sense litigation, but it's not a court process. It is a paper filing with evidence that goes to a administrative office of appeals within USCIS. They review the information and they issue a decision. The decision could be approving the application. The decision could be denying the application all over again, like dismissing the appeal or dismissing the motion to reopen or reconsider. Or it could be somewhere in the middle where a decision says we are going to reopen the case, but we also want additional information. And so then you're kind of going to get a new request for evidence and have to deal with all of that later, usually for an additional fee. So these are appeals or motions to reopen or reconsider with the AAO. Now, the second reason that I would file an I-290B decision would be in a case where the T visa or U visa wasn't denied because they thought our client was not a victim of the qualifying crime, right? So if they're saying it's not trafficking or they're saying it's not domestic violence, and that's why they're denying the application, oftentimes I will want to actually do something different, which is a lawsuit in federal court. I'll talk about that in a moment. But if the reason that the application was denied is because they think that the client has like a terrible criminal history or that they haven't met discretionary elements for an I-192 waiver of their criminal or immigration violations, then the I-290B may be our safest and best and clearest route uh, to try to challenge a denial. There has been litigation about whether you can even file a lawsuit if the reason for the denial of the T or U is related to the waiver part of the case as opposed to whether the person was actually a victim of a crime. I know this is getting technical, but it matters for strategy. So again, the first reason that we would want to file a I-290B case might be because we want to avoid a notice to appear for removal proceedings if the Trump administration comes up with that new rule uh, or reinstates their old rule. And then the second reason would be because it might be a situation where we have limited opportunity to address good moral character issues. And so we're trying to have that reconsideration done by the Administrative Office of Appeals. Okay, so, and of course, the overall reason is to win the case, right? I don't like it when immigration makes a bad decision. I try to take good cases and we want to win these cases. So if we're offering this option to clients, generally, our goal is to win, right? Okay, so an alternative option in many cases to a situation where a T or U visa case is denied would be to file what's called an APA challenge. Us lawyers, we just love to have abbreviations. We have whole conversations in letters and numbers and form numbers, but basically an APA challenge is an Administrative Procedure Act lawsuit. It says that the government has made such an error in law that we are allowed to file a lawsuit, typically in U.S. federal district court. Now we're talking real judges. We're talking filing an actual complaint that looks like a lawsuit, right? That the government has made specific errors. This is litigation. This is a lawsuit. Generally, these lawsuits are not trying to get money from the government, although there are some exceptions. Most of the time, this type of a lawsuit related to a T or U visa denial is really about trying to revoke the denial and get them to issue an approval. Now, one of the reasons I really like Administrative Procedure Act challenges, or we'll call it a lawsuit's going to be our short-term word for that, is because you have typically, not always, but typically up to 6 years to file a lawsuit like that. So if you're on a 30-day deadline to come up with the money to do an I-290B appeal, a motion to reopen, or motion to reconsider, that's really hard for a client. And it's also really hard for a lawyer's office to come up with all the beautiful legal arguments that we want to make in such a short period of time. So sometimes where we were able to file a lawsuit, when somebody either couldn't afford to pursue an appeal under the other way that I was talking about earlier, or didn't want to at the time, we had a longer amount of time to be able to file a lawsuit. And many times the limit is 6 years. But again, if it's your specific case, you're going to need to talk to us about what that timeline is going to look like. So the statute of limitations for this lawsuit is much longer than what we have with the AAO. That's a big benefit. Another reason I really like APA challenges or T or U visa lawsuits is because when you file that lawsuit, the government gets this complaint, and then they have typically 60 days to respond. And many times during that 60-day response time, we have seen that the government reopens the old case before it ever gets to a judge and revokes the denial, reconsiders it, and issues an approval or issues a request for evidence to resolve the problem. So it opens up a dialogue where sometimes the Department of Justice can communicate with us essentially on behalf of their client. Their client is USCIS, and say, okay, give us some time and we're going to see see what the new decision is going to be or how they're going to respond to this. And oftentimes they have seen the error of their ways and they've reopened the case, and then they issue an approval or some other instruction after reopening it. So another reason that we like to do lawsuits is that if we do this litigation, it it could mean that if the government opposes our lawsuit, meaning they're like, nope, we're doubling down, we don't think we're wrong, tell it to the judge, basically. Eventually, a federal district court judge who is a highly educated, appointed judge to federal district court who sees all kinds of different cases, that's the judge who's going to look at this. So they're not just kind of inside the immigration universe. And I've seen some written decision by judges like that that have just been amazing. Tremendous respect for victims of trafficking or other crimes, beautifully written analyses, um, a lot of protection related to the pseudonym or anonymity or confidentially, keeping this information quiet about the person who is suing. These are also things that don't get blasted to the newspapers, by the way. So if you're doing a lawsuit related to a T or U visa currently, generally that information is going to be sealed or unavailable to the public. The most is going to be like maybe the initials of the person or the last name of the person versus the government, and it doesn't go get blasted everywhere, but rather it's housed within Pacer, but people aren't kind of like able to access all of those documents. So there's a lot of protection there, which I really like. So another reason that we like to pursue these lawsuits is that even if the federal district court decides that they don't agree with us, there's an option to go to a circuit court. There's another level of review, and in some cases, all the way up to the United States Supreme Court. So you're getting different layers of review options. I haven't had to go typically in a case like this above the federal district court. They've generally all been resolved at the district court level, and there's been very few times where a judge even had to weigh in. Usually they're all resolved within that 60 days, or maybe a few months later after that time period. It might take them, like they might say, well, I would need a 30-day or 60-day extension to work through this, or there may be some negotiation points, or they may reopen the first case and approve it, but then the spousal case that gets reopened after that kind of gets delayed while they work through that for several months to make a decision there. But overall, the resolution times related to lawsuits does tend to be shorter than just an I-290B. Now, something you may be wondering is, can we do both? And we have done both. So I'll give an example under some of the strategies we used under the Trump administration previously. We may file an I-290B legitimately, which again had multiple goals: win the case, avoid a notice to appear for removal proceedings, all of that, give new evidence, create a better record, and maybe we lost. Well, if we lost the case, we could still typically then have an option in court. Not always, but generally that option is still there. So I had some cases where we did an I-290B and it was dismissed, and then we moved forward with the lawsuit. That lawsuit was ultimately successful, and then our clients got their immigration status approved. Our litigation success rate, if you think about just lawsuits, I think overall has been higher. Not to promise or guarantee any result, and any past results are not necessarily indicative of what would happen in the future. But, in terms of my professional experience as a board certified, North Carolina board certified immigration law specialist, I have seen a lot more sort of respect and attention to the cases that we've sued on, and we've had a higher success rate from the get-go with lawsuits when we've had that option. But if rules are instituted where they're saying we're going to have to do the appeal or motion to reopen or reconsider the I-290B part first, okay, then that's what we're going to be advising people to do most likely. Other situations may call for a lawsuit or litigation or APA challenges, are all the same thing basically off the bat. We also have some situations where we could do group lawsuits. You may also hear the term mandamus. That is a lawsuit that goes to federal court. It is not an APA challenge. It's not challenging the merits of a case. A mandamus lawsuit or mandamus litigation is requesting basically that a judge order the government to do its ministerial or basic job. So mandamus lawsuits are usually about speeding up casework. And we have some information, by the way, on our website at tarokiclaw.com that talks about delays and denials that you can read. And we've got it in English, but a lot of phones and the little global button that you can click can switch it into other languages as well. So if people want to read up on that, they can certainly do it. So those are the basics there. An I-290B is basically going to the administrative appeals unit. It's with immigration. An APA challenge or lawsuit or litigation is typically starting off with federal district court. And then a mandamus is really not so much the topic of today's conversation, but if you hear the word mandamus, it usually means we're trying to speed something up. And there are alternatives to try to speed things up, like medical expedite requests, going to congressional liaison assistance for some help there. But if you're looking at a mandamus, it's usually related to, we may have already tried that, or we don't even think trying those things will work, or maybe we'll try them simultaneously or consecutively. So there's a lot of strategies there. I know this sounds like a lot, but again, that's why specific legal advice is important to these cases. And I do consider all of our best options if we do receive a denial notice at the time, and then we advise our clients on what we think is appropriate and what we think we're capable of doing, at that time. So in terms of pricing or which one we're going to do, there's often not much of a cost difference between the two options. It's more about strategy and what we need to do and what were the reasons for the denial that we will make a decision what's the best one to do. And then I would also just say that, if you're talking to us and we're using the word appeal and it's an I-290B, we may also be looking at motion to reopen or reconsider because they do pretty much have the same vibe when it comes to what's actually going to go out to the government. And these are like box checking legal argument differences more than anything. If we're talking about a lawsuit or litigation or APA challenge, that's also basically an appeal, right? We're making a legal argument to the government. So appeal is sort of a general word that can refer to either of those two things. And when it comes time to decide what we're actually doing, our contract for legal services is going to specify what are those two things that we're working through with. And we do sometimes partner on litigation or lawsuits with an attorney who is very experienced and is admitted in the area that that lawsuit needs to be filed for jurisdictional purposes. So don't be surprised if we're looking at a lawsuit and we're talking about partnering to try to reduce costs to our client overall and also make sure that all the specific stuff on our part is done correctly and that we also have a partner in litigation to do these things together. That's been our recipe for success in terms of speed, accuracy, quality of representation, and it's something we've been basically doing since the previous Trump administration. I think we started back in 2018. So now 7 years later, we've been having, a lot of different experiences through different political administrations. And I'm sure that we'll have this continuing to be something that we deal with regardless of who's in power. But I do expect that we'll be looking at more litigation over time or more appeals or motions to reconsider if the government makes more errors during this Republican administration. So I hope this information has been helpful. I'm so glad this question was asked. And if people have further questions, they can always, reach out to us.
Well, thank you, Helen, for covering all the important terms related to litigation, lawsuit, and appeal. And I hope that clients would reach out if they have questions and book a consultation.
Awesome. Thank you so much, Maya. I appreciate you bringing this up. Have a great day, everyone.
You too. Thank you.